Just before the papers were due, a rather surprising and development, this paper is unexpectedly timely, when President Biden, in the waning hours of his term, announced that his long-held view was that the Equal Rights Amendment is in fact a law, that there are 28 amendments to the Constitution. The Equal Rights Amendment is the 28th. Now, this was slightly unusual because Biden did not instruct the executive branch to act as if this was so. The most recent OLC opinion, which would be binding on a number of executive branch actors in 2020 and 2022, did not take the view that the ERA is law, but nonetheless, Biden declared that it was. And this followed on campaigns in a number of quarters. The American Bar Association has taken this view. The American Constitution Society announced their view that this is the 28th Amendment. And a number of very prominent legal academics have also taken the view that the ERA is valid law. And why would this be a controversy if the ERA has been ratified by 38 states? Well, because the resolution adopting the ERA in 1972 stated that it would be valid when ratified within 7 years from the date of its submission by the Congress. And those 7 years expired in 1979. Before that time, by 1978, 35 states, not quite 38, had ratified. 4 rescinded their ratifications. I put that in scare quotes only because the validity of those rescissions is at least contested. In 1978, Congress then purported to extend the deadline by another 3 years to 1982. And there was the resolution notwithstanding any provision extending it. 1979, the original deadline lapses, another rescission occurs, and then 1982, the new deadline lapses, and no more ratifications have occurred. Then in the 20-teens, the view takes hold in some state legislatures that the amendment is still eligible for ratification, even without the extension, and so Nevada, Illinois, and then Virginia in 2020 ratify, bringing the magic number to 38. So 3/4 of the states have ratified the ERA, and so the argument is that's all Article 5 needs. So what's the problem? So I'm not going to say anything about the rescissions, though I think that it is a very interesting issue. I don't have a firm view on it. I commend to you Michael Stokes-Paulson's general theory of Article 5, which goes through the issue in more detail. But let's focus on the time limit, so that within 7 years. And there are 2 questions here. Can you have a deadline? And can the deadline be in the text of the resolution proposing the amendment as opposed to the text of the article that it proposes? The first such deadline shows up in Section 3 of the 18th Amendment proposed in 1917, and it says this article is inoperative unless it's ratified within 7 years. The Supreme Court holds that this does not invalidate the entire amendment, as someone who was convicted under a prohibition prosecution argued. Then the 20th and then 21st and 22nd Amendment all have similar inoperative provisions. When we get to the 23rd, they change things up, though, because they move the time limit into the text of the resolution proposing the amendment. They say it will be valid only if ratified within 7 years. This is after Professor Dowling of Columbia suggested that it could go there and it will be equally effective, and this way it will avoid an unnecessary cluttering up of the Constitution. Why have this rule in the text of the Constitution that is, immediately upon ratification of no further interest? And so the 24th Amendment also repeats that language. The 25th Amendment says, varies it slightly, it will be valid when ratified within 7 years. 26th Amendment does the same thing. ERA does the same thing. And the DC Voting Rights Amendment, proposed in 1978 and never ratified, takes no chances. This is going on during the extension debates. And they say not only will we have a within 7 years provision in the proposal in the resolution text, but also in the text of the article being proposed. We'll have 2 of them, and hopefully one of them will work. So what should we think about all this? And my contribution here is relatively limited, but I noticed something weird when I had reason to look at the 12th Amendment resolution for other reasons, which was that Congress seems to have used these kinds of operative legal provisions in proposing language before. In the Bill of Rights, in the 12th and 17th Amendments, in a number of draft proposals. And the view that I think this supports is an idea that the resolution is the amendment, that if we're trying to figure out what is Congress proposing, it's proposing a change, and that change is spelled out in the resolution. Now, that change could be adding text, it could be deleting text, it could be changing text, it could be doing something else entirely. Whatever it is, the proposal is what Congress proposes, and it doesn't necessarily have to take the form of a block of text to be added to the Constitution. In the Bill of Rights, we see that the resolution says we're going to propose some articles, any or all of which articles shall be valid. So what the resolution is doing is saying these are a bunch of independent proposals. And that's important, because if the House and Senate had just traded off a bunch of independent joint resolutions to each other, there was a danger that the Senate might not agree to everything that the House had wanted, or vice versa. And likewise, if they sent out a single package to the states, that single package might need ratification by 3/4. They need a way of separating out these proposals as distinct, and the resolution language legally, operatively does this. In the 12th Amendment, we have something even more striking. They adopt the new text to be added in lieu of particular text in the existing Constitution. And this was debated. They were arguing about how do we unify the existing text with the stuff we're going to add. And the answer they come up with is cut out some stuff and paste in other stuff. And it'll be at the end. It's not in its place. In the way that Madison had proposed for some of the original amendments, but it will act in lieu of that existing constitutional language. Same thing for the 17th Amendment, in lieu of this paragraph and so much of that other paragraph as concerns vacancies. Likewise, in proposals, this is an 1851 proposal by future President and all-around not-so-great guy, Andrew Johnson, and he says, look, we're going to change the word legislature and put in something else so that it will read as follows. So the resolution is proposing a change, which is not just a piece of text that you tack on at the end. So this suggests various possibilities. We could have a resolution that adds text the way we're used to. We could have a resolution that just says, propose that the Constitution be amended by repealing Article 6, Clause 3. That would be one way of doing it. There's no text added to the Constitution by this, but presumably it would be just as much of legal force. Or you could have the hybrid Andrew Johnson approach, or Congress could propose an amendment with hieroglyphics if they want, so long as we understand what change is being made to the Constitution. This means, if that's right, that you could do a variety of conditions in the resolution text. You could put in an effective time limit, and if you say the following is proposed an amendment and the inoperative provision is in its text, well, the text will go in when it's ratified. It'll just be inoperative. So we've added to the text of the Constitution, but the new text just doesn't do anything. It's sort of like adding an amendment to wit, this amendment shall do nothing at all. Like we've added to the text, we haven't added to the legal content of the Constitution. Or you could have something ERA style, amended when ratified within 7 years. It adds that text only on condition, and if the condition is not met, the text is never added. So it's sort of like ratifying an amendment that says that the Constitution be amended in the following manner, namely not at all. You have successfully made an amendment constitutionally operative, constitutionally valid in some sense, but you have not in fact changed either the text or the legal content of the Constitution. It is an empty breath. And that, I think, is what the ERA is best regarded as. But you could do other things with the resolution text. You could add an effective date 2 years after it's ratified. Transitional provisions don't affect the election or term of any senator. You can do all those things that clutter up the Constitution if you really wanted to in the resolution text rather than the text of the amendment itself. Now, I'll note this makes it a little hard to print up copies of the Constitution if we have these weird things that aren't extra text. But maybe that's just the printer's headache, and it's not actually a limit on Congress in terms of what they can and cannot do to the Constitution. Think of the comparison between the statutes at large and the US Code. Sometimes they cut and paste sections of the US Code, sometimes they just say stuff, and then the compilers of the US Code have to get it right to figure out what provisions go where. Some implications. It seems from this that there is no real distinction between article text and the resolution. I'm not saying that I have proven this, but that seems like the most reasonable conclusion to draw from the frequent use in Congress, going all the way back to the beginning, of resolutions as the source of the constitutional change. The proposed article is in the resolution. The thing that makes it an amendment is that the resolution proposes to amend the Constitution in some manner. And so it's very strange to say that the resolution is sort of some legal nullity and only the article text matters when the article text is in the resolution. That's what gives it legal force. If the resolution didn't have legal force, the article text wouldn't either. Some of those resolutions add text, some don't, some make other kinds of changes, and what we want to know is what change is Congress proposing. It also means that we don't need in Congress a special time limit power. This was the theory behind the 1978 extension. Maybe there is one, maybe not, but it's very hard to override conditions that are in the amendment that was proposed. Think of the in lieu of provisions. Could Congress add more things in the Constitution that new text is to be in lieu of already after the resolution's gone out? That seems very unlikely. And furthermore, it doesn't seem like this picture is one of changing the rule of Article 5 or contradicting the rule of Article 5, but merely specifying what kind of change we want to make. You could add an amendment that would be inoperative unless ratified by every state. Obviously, that's different than the 3/4 rule, but it's a distinction between whether it's effective and what it actually does. So you need 38 to add something to the Constitution or to give the proposal, make it operative. But maybe if it says it's inoperative, then it doesn't actually do anything. And it's not necessarily Article 5's job to change how that's going to come out. In some contexts, like Chadha being the best example, we don't allow Congress to say, well, this is just conditional legislation, this is just sort of dependent on what happens later on. We don't say the broader power includes the narrower one. But I think that that is the correct analysis here. Because when Congress is acting pursuant to its legislative powers under Article 1 or elsewhere, it's doing so with sort of delegated authority that comes in a limited way. Chadha, for example, had to be necessary and proper to some power vested in Congress or some other branch for that to be the law. But amendments can do anything. Congress can do anything with a proposed amendment that the framers could have done at Philadelphia. Surely the framers at Philadelphia could have said this provision, the contracts clause, is going to be valid only if ratified within 7 years. So it's really hard for me to see an argument for why Congress cannot do the same and could not say, we're going to make the following change to the Constitution, but it's only going to actually add some text if some further condition is met. So thank you very much. Apologies for going over, and looking forward to your comments.
Thanks, Steve. And let me first say thank you all for inviting me here and for the opportunity to comment on this paper. Anyone who's looked at the piece I wrote with David Posen about Article 5 knows that I love diving into the procedural minutia of the amendment process. And so this is a genuine pleasure to read and to think about. So my questions are going to cluster around 3 distinct issues, which is first, what can we learn from this really interesting history that Steve has unearthed? Second, stepping back a little, what is it that legitimates constitutional change in the first place? How do we think about that question? And then third, how do we settle disputes about the meaning of Article 5? Okay, so starting with the history, Steve first ascribes significance to the fact that Congress, in proposing the Bill of Rights, specified by resolution that the states could ratify any or all of the proposed articles, as he put up on the screen a moment ago, and that this is an early example of what Steve calls a resolution containing a binding procedural instruction. So I guess I want to just pose a different reading of this, which you to some extent anticipated in your comments, which is just that Congress has the power to propose amendments. If it wants to add text to the Constitution, it has a choice between proposing a single long amendment or several discrete proposals that can be ratified separately by the states. The any or all language in this proposing resolution just expresses the latter choice, right? It's merely specifying that the 12 articles should be taken as 12 different proposed amendments, and that kind of specification seems to me, at least, a pretty obvious incident of the power to propose amendments in the first place, right, to shape what those proposals actually are. Congress could, for example, as Steve acknowledged, have passed 12 separate resolutions proposing 12 separate amendments, which became the Bill of Rights. And what Congress indicated in this resolution was the functional equivalent. So I guess it seems to me that the relevance of this episode to the ERA may be somewhat limited in that Congress did not, in this resolution, purport to control the process by which these proposed amendments would be separately ratified in the states, just specifying that they were separate. Okay. On the in lieu of language in the proposing resolutions of the 12th and 17th Amendment. So here, I read Steve's argument to be grounded in the contention that this in lieu of language, as he puts it, seems to have been accepted as legally effective. And I guess my basic question is, how do we evaluate whether this at the time was indeed taken as legally effective? Or put another way, what would it look like to not be accepted as legally effective? Because as Steve notes in the paper, perhaps we'd have read the 12th Amendment much the same way regardless. I think we almost certainly would. And indeed, since no one has seen or commented on this in lieu of language before, the fact that we have read the 12th Amendment in the way you propose suggests that maybe it didn't have an obvious legal effect at the time. The 11th Amendment, for example, which was ratified not long before the 12th, didn't have the in lieu of language, as far as I know, but was clearly understood to repeal part of Article 3 in the way that the 12th Amendment, with this in lieu of language, was understood to do as well. The 12th Amendment was treated the same way, in other words, and I believe would have been treated the same way with or without this in lieu of language in the proposing resolution. And I guess I want to suggest even more, again as a question, isn't contemporaneous practice arguably inconsistent with the in lieu of language in this way? It seems to me that to truly give legal effect to that phrase, our constitutions should be printed differently, right? With the 12th Amendment and the relevant text in Article 2 rather than put on at the end. So imagine that I'm in the editing stage with a law review editor, and I email my article's editor at the law review. In lieu of the penultimate paragraph of my conclusion, please add this text, right? And then I get the PDF of the final version that goes out to the printer. That original paragraph is still on there, and my new paragraph is just tacked on at the end. I think I would be quite irate at having my instructions disobeyed. And it seems to me that by printing the 12th Amendment at the end of the Constitution rather than replacing the text, the resolution was, if anything, ignored. At least that's possible. I pose that to you. And I guess as a final point, I think the very novelty and creativity of Steve's argument may be kind of a strike against it in a way, right? As Steve points out, this historical practice has gone almost entirely unnoticed by scholars. If these proposing resolutions that Steve has found are indeed part of the Constitution itself, it would be quite shocking if they had never been noticed before until this moment. Okay, so that brings me to this kind of broader conceptual contention that Steve derives from this history, that the resolution is the amendment. And I think I largely agree with him. But I want to suggest a refinement, which may be a little bit simple-minded for understanding what an amendment is. And I think this kind of flows from the language of Article 5 itself. So specifically, a proposed amendment is a proposed change to the text of the Constitution, right? So the Constitution's a written text. Article 5 says that Congress can propose amendments to this Constitution, which become valid as part of this Constitution when they are ratified. And to me, the wording of Article 5 suggests that what Congress proposes is an alteration of the text. Now, typically, Congress proposes new text to be added to this Constitution, but it's at least theoretically possible, as Steve points out, that a resolution could delete or edit text in the existing Constitution, though that's never happened before. So for this reason, I agree with Steve that an amendment is not just new article text. It's a change to the text, which can include a deletion. But I think the upshot is that everything in the resolution that would change the text is the proposal, and everything in the resolution that would not change the text is not the proposal to amend this Constitution. So with that, I think the wording of the proposing resolutions that Steve put up on the board supports this understanding. They all say some version of this. The following article is proposed as an amendment. In other words, the amendment is the amendment that's actually proposed is the change to the text, right? It's the following proposal that gets ratified by the states. That's what actually gets sent out, and that's what ultimately becomes part of this Constitution after the ratifying process. So if that's right, then arguably, and again, I pose this as a question, the ERA resolution is distinguishable from the 12th and the 17th Amendments because both of those resolutions that Steve has unearthed contain an alteration to the text of the Constitution, right? In other words, they specify certain provisions that should be regarded as nullified, if not deleted or replaced. The deadline on the ERA, as on the other hand, does not alter the text itself of its own force, right? It just sets a condition on the process of alteration. So that, in a way, might render the analogy somewhat imperfect. Okay, so that's the historical stuff. And now let me just zoom out and ask two broader questions. And so the first is, what is it that makes a change to the Constitution legitimate in the first place? And specifically, does wide public acceptance of an amendment ever wash the amendment clean of any arguable questions raised by the process of ratification? So let me put this in the form of a hypothetical. Imagine that the ERA was ratified by a sufficient number of states after the expiration of the initial 7-year deadline, but during that 3-year extension that Congress had granted. Both Congress and the OLC accepted the ERA as valid, and it was published by the archivist. I guess then it was technically the Administrator of General Services. The courts begin applying the ERA in litigation. The Supreme Court never questions its validity. You and I, Steve, both grow up learning that the Constitution has the ERA in it. It's in our history textbooks in high school. It's in our pocket constitutions when we're in law school and when we're lawyers. And now imagine that you made the discoveries that you just made in this article in the last year or so. Would you still argue that the ERA is invalid in that circumstance? Or, to borrow Richard Fallon's terms, at a certain point, does the sociological legitimacy of a constitutional text overtake its legal legitimacy as the relevant criterion against which we judge it? And then the final question is just, I agree with Steve that the uncertainty around the status of the constitutional text is very unsettling and even dangerous. But I also very much agree with the first sentence in Steve's abstract, which is whether the Equal Rights Amendment is, right now, part of the Constitution is a matter of serious dispute. And much as I admire this paper, I'd be willing to bet that it will not end the dispute. So the question to me becomes, how do we resolve this dispute, right? And so borrowing a term from the legal process school, I think the most urgent issue right now in Article 5 theory is this question of institutional settlement, right? What institution has the power to judge whether Article 5 has been complied with in the ERA's case or in any other case? Obviously, one option is the Supreme Court. On the plus side, you have Charles Black's insight that the Supreme Court can be a powerful legitimator of government action. On the downside, many amendments don't give rise to justiciable controversies, right? I think the 22nd or the 25th. Option 2 would be Congress. This option has some support in Coleman and especially in Hugo Black's opinion, but Congress has not exactly covered itself in glory as an interpreter of the Constitution, at least in recent years. And then finally, there's the archivists working in conjunction with the OLC or the executive branch or the president in some form. And so my final question is, which of these avenues strikes you as the best way to resolve the validity of the ERA and any other future amendment? If the dispute right now is serious and dangerous, as Steve suggests and as I agree, can we at least agree on a process to resolve it whose outcome we would accept?
Thank you. So I think there are 4 topics that I want to specifically look at. One, sort of, do these examples, if not prove, sort of, suggest as much as I think they suggest? Second, sort of, is there a requirement that Amendment be a proposed change to the text of the Constitution? Third, what do we do about sort of popular acceptance, sociological legitimacy, and then fourth, the who's to judge point. So on the first point, so I think that we do know if they were legally effective, in part because we can see what people said about them at the time. So in the debates, they're talking about different ways of dealing with the existing structure of the Electoral College in the 12th Amendment and how they want new elections to go and which parts of the Constitution they want to stay in place and which they don't. And the proposal is made and later taken out and then added back in. Like, look, this is really complicated. Let's just clear the decks by saying in lieu of this whole section, and then let's just rewrite the whole section with the changes we want added in. And they say this, and then when the states ratify, all of them except New Jersey, I think, repeat this in one way or another. Most of them just repeat the whole resolution in nec verba, which I think is normally how ratifications work, but some of them don't. They add the new text, but then they say that this amendment, in lieu of these things, is hereby ratified. So the states definitely perceive the in lieu of as part of the amendment they are being asked to ratify. And so I think that that's very probative evidence. If, in fact, they hadn't done that and it totally disappeared, I think it would be much more complicated to explain what was agreed on between Congress and the states in that instance. 17th Amendment, same thing. They all go through, and some of them even say, as a substitute for this part of the Constitution, we are hereby ratifying. So it seems like it is and when they're editing the text of the 17th Amendment during the drafting process, they edit which parts it's acting in lieu of. So they definitely seem to think this stuff matters, and it's not just boilerplate. Now, you're absolutely right. We would ordinarily read the amendment to do pretty much the same stuff. It's the in lieu of clauses are for the avoidance of doubt. They are making clear which things we think we are editing and which things we think we aren't editing. So that like the 30-year-old requirement stays good because that is not part of the section that refers to vacancies. And so therefore that's still effective and nothing we're saying deals with that. You could say that in longer text, but it's sort of easier to do it this way. So I think that we do know these things. And that novelty in that sense isn't a problem because everyone was so agreed on it, they didn't need to, sort of none of the interpretive problems cropped up. On the point that an amendment is a proposed change to the text of the Constitution, I'm not so sure. So for one thing, you could have proposed changes to the text that could be conditional or could take effect at different times. So resolved that the following change to the text be added 2 years after ratification, and this other change to the text be added 4 years after ratification. It's not obvious to me that Congress can't do that as part of its power to propose amendments. Moreover, you could have something like the 11th Amendment, which says the judicial power of the United States, if I'm remembering it right, shall not be construed so as to do X, Y, Z. It would be hard to do that repealing any part of Article 3. We don't want to get rid of state diversity jurisdiction. We just don't want it to be read as if it permits private citizens to sue states. And so you can imagine that the 11th and 12th Amendments were added together. It would be resolved that the following be proposed as an amendment, namely that the judicial power not be read in this way, and also that we add the following text in lieu of section, this section. So you could have something where the resolution explicitly makes clear that it's making a rule of construction addition to the Constitution that is not necessarily to be added as a new article, and that it's adding a new article. And I think that it would be a real stretch, given the Article 5 that we have, to say that that first change is constitutionally invalid, because it doesn't specify any edit to the text rather than merely instructing us as to its proper construction. One could have that rule, but it seems sort of super added to what Article 5 says. So now let's think about sort of what makes an amendment valid. So in some sense, I'm a positivist. I think that ultimately this rests on some sociological facts, but we can have sociological facts of different kinds. So I think it is perfectly plausible to argue that West Virginia was improperly added as a state. Depends on the meaning of a semicolon in Article 4. And Michael Stokes-Paulsen and Vasan Kasavan have the celebrated article on that. I think, thankfully, they are correct that West Virginia is okay and it is a state. But I think that if we are committed both to the rule that Article 4 specifies how you add new states, and also, here are all the new states that have been added, it's possible for those two things to contradict one another. It's possible that our commitments at the level of how you add states are different from what we would assume are all the list of 50 states. And so the question of what we will actually do when push comes to shove is a sociological question, but a question of what do our rules currently prescribe for what is the correct constitutional answer right now before we have all declared that we don't care what the semicolon meant. Is, well, Congress could only add West Virginia if in fact that was within their powers under Article 4. That's our official explanation for how West Virginia came to be, is that Congress has a new state's power, and so on and so forth. And what that means is that we have to have different legal and sociological answers to how we would resolve the dispute. So legally, I think the correct answer is departmentalism. You know, the executive can take a view on whether the ERA is valid. Congress can pass statutes, you know, asserting or assuming that the ERA is valid. The courts can rule in appropriately presented cases. But there's a question of the answer, and then there's a question of what various government officials think the answer is, and those don't have to line up. And as a matter of sociological legitimacy, all sorts of stuff. You know, George Clooney endorsing the ERA might have more sociological force than, the Third Circuit saying so, even though it has no legal validity whatsoever. And so, man gets used to everything, the beast. You know, like how it is that we will actually become, accustomed to a new amendment is a totally separate question from legally, is that amendment valid under Article 5?
It seems that part of what's at issue here is an amendment a change to the text, or is it a change to the law of the Constitution? Right? Having posed it that way, we know which way Steve will answer it. And
getting typecast here.
And part of what's interesting to me about this is that Steve, I think it commits you to the position that there are texts that are part of the written Constitution in every way that are not part of the pocket Constitution that we carry around, right? That there's no distinction between that part of the textual Constitution and the part of the textual Constitution that everybody knows to be the textual Constitution. I wonder about that. I also wonder, as I was listening, I thought the person from the world of jurisprudence who I might most recruit to support Steve's position is Mark Greenberg. Right, because he would tell us that the content of the law is the change made to the full content of the law by the particular act, which seems to me to be the view that you are acting on when you say that the resolution is the amendment. And since I normally think of his view and yours as in delicately tension with each other, I wonder how that strikes you. The last thing I wonder is, if you happen to know, at the time the 12th Amendment was adopted, were there people who said, we should now print copies of the Constitution without Article 2, Section 1, Paragraph 3? Were there any copies of the Constitution printed that way? And how would you feel if you were printing constitutions about doing it now?
I just wondered whether there's a difference between the 12th Amendment's proposal language, which is indicates the intended substantive meaning of the textual provision of the amendment, and the ERA's proposal language, which imposes a procedural hurdle above and beyond what Article 5 requires. The latter seems potentially more likely to be a qualitative addition to the procedure set out by the Constitution, and we know from cases like the term limits case, which you may agree with or not agree with, but there's at least a sound argument, a plausible argument, that if you add conditions and qualifications to a process that is identified in the Constitution, that's inconsistent with the constitutional text and thus inappropriate. It seems seems that adding procedures changes the methods by which these amendments are adopted, that it's effectively, you're allowing Congress to amend Article 5 for this particular purpose. I wondered how you would think about a rule adopted by Congress as part of its own its own ability to set its own rules that said that for a constitutional proposal to be admitted to the states, the Senate must vote unanimously on it. Or, again, seems inconsistent with the language of the Constitution. It seems to me that you're making a lot of it in lieu of language. And I get it, and I get your argument, but I think that it's not that the in lieu of language has force because it was in the proposal. It's the in lieu of language has force because it reflects the original public understanding of what the proposal did. And so it's not that it's in the proposal that makes it important, and presumably if it weren't in the proposal, but everyone talked about it as in lieu of, it would have the same force. So I'm just wondering, is it really its existence with that language in the proposal that gives it its force, or is it because it reflects the original public understanding of the 12th Amendment? I think we'd agree that a resolution providing that less than 3/4 of the states can make a constitutional proposal valid as an amendment would be unconstitutional. But I'm not sure why that is if we're going to allow Congress to adopt other kinds of procedural barriers to amendment that are not part of the amendment process under Article 5.
So you start off by saying how important it is to at least have consensus on the text of the Constitution. So it's ironic that I came away being less certain about what the text of the Constitution is. My question's pretty much similar to Richard's final question. You say, of course, that with the in lieu of language, the prior text wasn't erased from the Constitution. There's no more of a problem in printing a Constitution that includes Clause 3 than there is in printing one that includes the 18th Amendment. So my question is basically, why the of course? Why is it so sure? I know you point out that there was that expunge language in an earlier version of the resolution that was then taken out, but even without that expunge language, couldn't in lieu of be interpreted to mean delete and insert? And if not, what language do you think would be necessary to be interpreted as meaning delete and insert?
Thank you to all three of you. Starting on the last question, because it also goes to Richard's. I think it would just be a question of, legislative drafting practices as of the time to figure out when are they trying to literally delete and when are they trying to sort of replace. I do think that the 18th Amendment is not part of the legal Constitution in some sense anymore. If we think of the ideal object, the Constitution, the 18th Amendment has been repealed. And you can imagine in the US Code, when something gets repealed, they print like Section 7 bracket repealed period. They don't even tell you what it said. And so you can imagine that being the way that we print the 18th Amendment. And I don't think there would be anything legally wrong with that. I just think that it is helpful to often have the text of that, and likewise, it is helpful to have Article 2 say what it says with the footnote and the brackets that say this portion has been replaced by Amendment 12. Indeed, all of the fact that it's Amendment 12, like if you look carefully at a copy of the Constitution, the 12 is in brackets. Because the 13th, 14th, 15th, and 16th Amendments, they actually put the number in the amendment when they ratified it, or when they proposed it. And the others, they just said article dash. And the editors of the pocket constitutions replaced the dash with the actual number because, of course, Congress doesn't know in what order its amendments are going to be ratified, and they hope it's 13, 14 through 16 are going to be ratified in the right order. But if they had messed up and they proposed something else that got ratified first, you'd need some brackets there. And so, like, the text of the Constitution and its legal content, I do think, are two distinct entities, and you can imagine amendments that focus on the legal content without necessarily adding text. And it would just be the printer's headache to figure out why that would be so. And that doesn't change the fact that our Constitution, as it currently stands, is a textual Constitution. And it doesn't, it strikes me that the sort of philosopher to bring in wouldn't be Mark Greenberg, but rather Bentham, who complained about the fact that every time Parliament enacted a new statute, it was like water poured into the sea. You sort of dump it into the corpus juris and mix it around, and you see what happens. And I think that is correct with regard to the Constitution too. You know, most of the time we do it through very neat textual packages that you tack on at the end. There are good reasons for that. But if Congress chose to add a rule of construction and then add some text, I don't think we could force them out of that so long as we knew what amendment they were actually proposing. I think that's up to them. How much, I mean, and this was debated during the first Congress when Madison originally proposed, delete this language, insert this other stuff. People were like, no, it'll be too hard to know what the Constitution said at different times. We should add them on at the end, you know, et cetera, et cetera. But that kind of back and forth debate, some people favored Madison, some people favored the other approach, some people didn't care and thought it was a waste of time. And so how we structure the amendments, I think, is totally up to Congress to decide. Finally, on the question, and I don't know how copies were printed after the 12th Amendment, but there at least were some copies that I've looked at, like a State Department literal print from 1933 that has the in lieu of clauses. So it's not that no one has ever seen these before. It's just that, you know, since the start of the Westlaw JLR database, no one has been paying much attention. And then finally on the question of like, what are the other things that they could do? I don't think there's a difference between substantive meaning versus procedural hurdles. And the reason I don't think that is because of stuff like the 18th Amendment's inoperative clause. So I see that as the provision of when this text is getting added or what this text is going to do at different times is just more content of the thing we're changing. And so, you know, I don't see it quite like term limits in part because Congress, when it seeks to super add term limits, or a state doing so, is only using a limited kind of power. Whereas I see the Article 5, I mean, as long as you're not disturbing equal suffrage for senators, you can do literally anything. You can repeal the presidency, you can add a fluctuating number of presidents, you can make the US part of France on Tuesdays and Germany on Wednesdays, like you can do literally anything you want. And so it's very hard to say that they couldn't do this. Now, the reason why they can't make it less than 3/4 is because it just hasn't been made valid as an amendment until it gets 3/4. But if it is effective as an amendment, but just tells us don't add this text yet until we get all 50 ratifying, that's up to them. And likewise, the Senate already could have a unanimity rule just by rule of the Senate. They could say, you know, we're going to have a first vote on whether to consider the amendment, and if it doesn't clear unanimity, then we're not going to have the second vote. And that's just part of their rules of proceedings power.
Could I maybe just ask one clarifying thing following on Adam's question? So if we assume for the moment that rescissions are not valid, would your position then be that the ERA resolution has been ratified? It's just that it is rendered inoperative by its own terms.
Yes, the ERA resolution has been given as much force as Article 5 can give it, which does not include changing its terms to add some text to the Constitution that Congress didn't tell us to add.
Thank you for this paper. I learned so much, and it's just typically brilliant in the Sachs way. So I have a suggestion for you.
Protected Sachs.
I have a suggestion for you. The sort of the short version of the suggestion is to take into account Jason Mazzoni's interconstitutionalism article. The long version of the suggestion is to look at the practice of state constitutional amendment and to consider the possibility, I love it that I'm saying this, to consider the possibility that the general law included a law of constitutional amendment that pre-existed the Constitution in state constitutions, and that this general law has continued to develop, not only in the practice of amendments to the United States Constitution, but also in the practices of the states with respect to state constitutions. You're assuming sort of a textualist U.S. Constitution provides all the law approach, but it might be that there is a general law of constitutional amendment, and it seems like you might want to explore that possibility.
I missed the April Fool's edition of the Legal Theory blog very much.
So just a second thing, and this has to do with Thomas's discussion of sort of what you recharacterize as sociological legitimacy. And it just seems to me that it would be worth your discussing the possibility that the rule of recognition, which is a social rule and is not just a matter of sociological legitimacy. The rule of recognition determines the content of law, what counts as law and what doesn't. That when we are talking about borderline cases of constitutional amendments, that it may be that we look to the rule of recognition rather than to prior legal practice. And rules of recognition, you may disagree with this, but rules of recognition, in my view, are not static. Rules of recognition change over time, and they change in response to all kinds of factors, deep controversies over whether, and deep and divisive controversies over whether or not something is part of the Constitution, as there were about the Reconstruction Amendments. And I'm not sure that we currently have a really, truly deep controversy about the ERA, but we might have one, and that those controversies may provoke changes in the rule of recognition. And this is an alternative explanation. This ties into Thomas's point that your theory, and I must say I'm very persuaded by it, right, despite Thomas's objections. I'm very persuaded by it. But I don't know whether it can possibly be the explanation for why we have the Constitution we have now, at least with respect to more recent amendments, given the novelty of your theory, right? It just seems like it can't be playing the kind of an explanatory role if no one knew about it. Something else must be doing the explanatory work. It was just such a pleasure to read the paper, and it was so very, very persuasive.
All right, I guess we're all original law originalists now. Question on I kind of have a hypo that I wonder how this would affect the law of interpretation. So imagine 20 years from now, there's general agreement that something needs to go into the Constitution to prohibit sex discrimination, but Congress can't agree on the text. And so what they agree on is repealing Section 3. And that passes through the normal amendment process, the time limit, the thing that says it's not operative. Two questions with that. One, what would happen when you repeal the thing that makes the law legally ineffective? And second, and maybe this is an unfair question to you, I was going to, from a public meaning originalist, or at least some originalist perspective, how do you do originalism in that case? Should it be the meaning when it was initially passed? Or should it be the meaning, which may not converge, of when they repealed the clause that made it legally ineffective?
I found this a very thought-provoking and enjoyable paper, and I also find it almost completely persuasive. I'm a bit agnostic on this issue, whether the resolution is actually part of the Constitution, but the idea that the ERA cannot be part of the Constitution because of these arguments on the history of the resolution seems conclusively persuasive. One might wonder why I put myself in the queue then, but it's, I think it does show. I wanted to throw out a few points, which I'd be interested to get your reactions on, as well as any of our colleagues here. I thought the one point that was most persuasive to me was the idea that if by some chance putting the time limit in is not in accordance with Article 5, then the default outcome can't become that the amendment's valid when it's ratified contrary to the resolution, but that the resolution itself fails, and so it's self-defeating in that sense. So in that sense, the advocates saying the ERA is not subject to the time limit are inadvertently making an argument to nullify it completely, because then the resolution was not valid. I did want to press you a little bit. I know you conceding you bracket this issue of the rescissions, but as a 14th Amendment buff, and since that's the other amendment that's affected by the rescissions, I kind of did want to press you a little about that. I'm curious if you had views on it. I think it's maybe a bit more debatable, but still a very powerful argument against the possibility of the ERA taking full effect. And also, I think it is, for me, I guess, I think, and I think about people, and there are actually more than a few, who are strong political progressives, which I identify as, but also consider myself some type of originalist. And so I strongly favor the substance of the ERA, but I've been kind of puzzled and disturbed that there's such a widespread view among my fellow political progressives that it's somehow still valid. And I can't help, surely someone's offered this hypothetical. Suppose an amendment was proposed by Congress with a time limit to repeal birthright citizenship. And then it falls short, the time limit gets extended, there are all these questions raised, and maybe it finally gets 3/4 of the states after an extension contrary to the resolution. Would all of the same voices be advocating for the validity of that amendment? I think we all know the answer to that. So that's kind of a troubling implication of this too. Does it all come back to, is it all contingent on whether people support the substance? Is the procedure and all this just, is it being brought in post hoc? I think your account is totally persuasive, and I think you're taking a totally sincere view. And I just say, as a progressive originalist, it seems utterly persuasive to me, and I hope there's some lessons here that maybe would benefit people who are skeptical of originalism. So anyway, just interesting paper.
Thank you so much. And to go in order, Larry, thank you very much for your kind comments. I will definitely look at Jason's paper. If I can get you talking in general law terms, I feel like something great has been achieved. So I don't know if there are other rules relevant to constitutional amendments not found in the text of Article 5 of which I should be aware. And so, if, for example, there was a very strong sense that sort of amendments had to be changes in text, that would matter a lot to me. I don't think there was, in part because a lot of the proposals that came out of state ratification conventions or early proposals when Madison was going through his list, some of his changes were editing, some of them were tacking on, some of them were just declarations, that all power is vested in the people, and so, things like that. And so I just don't know that there was a specified form that amendments had to take, but if so, that would certainly be relevant to both the interpretation of Article 5 and to sense of what was done thereunder. And I also agree with you the possibility that the rule of recognition can change. I think that part of the problem is identifying when it has. So, again, look, on our paper on the official story, I think it's significant that our official story of the Reconstruction Amendments is not, yeah, there were some shenanigans, but you know what, they're law. But rather, I think something closer to John Harrison's account, which is, no, they got ratified by 2/3 and 3/4, and that's what you need. And yes, the ratification process was, with sort of federal troops on the ground, but that's, still got 2/3 and 3/4. And so, like, the outsourcing to that rule suggests that we don't actually have a change in rule of recognition, but rather just a widespread belief that the conditions for adoption of the amendment were satisfied. And if that turned out to be false, then we would have a dilemma, and maybe the rule of recognition would thereafter change. But saying what the state of the law is now is not the predictive claim about what will happen when people realize that there's this tension. So the best account of the current law is as it is. And I do think that the novelty of this might be a little overstated. It's certainly true that the in lieu of clauses get no attention, but there have been lots and lots of drafts doing lots and lots of weird stuff. And so I don't know that when Senator Kefauver started putting the time limits in the resolution text in the 50s, that was so outlandish, because even recently there would have been other draft amendments, which I don't really go through in detail in the paper, that did weird things with the text. So it may have been less novel to them than it is to us, which is a standard originalist phenomenon. Rob, I think it's a really interesting question. So suppose the 18th Amendment got ratified late, and some joker state decided to ratify it anyway, even after the 7 years had passed, and so now it's part of the amendment, but it's part of the Constitution, but it's inoperative. And then a later amendment says repeal Section 3. I think that would be perfectly effective, and it would revive the 18th Amendment thereafter. It would be a little complicated to word it for the ERA, but I think that you could say, as a new amendment, the amendment text proposed back then is to be regarded as valid as of when Virginia adopted it, the 7-year provision notwithstanding. I think they can do that because they can amend the Constitution. So they could just say, add this text effective that date. It doesn't seem to me that they couldn't do such a thing by amendment. And as to the question of the meaning, I think it would have to be, if they're reviving something old, the meaning that it had. I mean, I think, or at least that would be the natural assumption to me, is that we want that thing back then, whenever it was, to be revived. Not, we might have false beliefs about it of all kinds, but the thing we want revived is that. You sometimes find the state ratification instruments not really specify what the amendment, what they're ratifying was. It's sort of like, that their amendment Congress done passed about senators is hereby ratified. And that's good enough. As long as we know what, they're talking about, they don't have to spell it out in detail if they don't want to. And I think that Congress could do the same thing. They could propose, hey, that thing we proposed once? Yeah, and so long as everybody knows what they're talking about, I think that would be effective. And then finally, sort of question on if the time limit is bad, why doesn't the whole resolution fail? That was, I think that's a persuasive argument because it takes two to tango. And so Congress did not propose an unlimited time amendment. They did start off with one, but it failed. And so the next Congress, they came back and proposed one with a time limit explicitly because they thought they would get some moderate votes they wouldn't have gotten without it. And that's what was agreed to. And so I don't think that one can magically transmute that into an unlimited amendment and say now, 50 years later, that it has become valid law. I mean, indeed, that was the number that people trotted out. They said, we need this time limit so that it won't be roaming around 50 years from now. And lo and behold. And I also, I'm just not sure what to think about rescissions, because on the one hand, Paulson argues that these are sort of legislative acts, so they can be enacted and repealed. And so that's sort of his view that rescissions would be valid. On the other hand, if you think of it as like a very large multi-member legislature, if the House passes something and then says, oh wait, we unpass it, I don't think that matters to the Senate. I think they're allowed to pass it themselves and send it to the president. I don't know. Maybe others have better knowledge of legislative procedure here. But I think the official rule for the House and Senate in bicameralism is no takebacks. So it might be similar here. I don't know.
Sorry, just real quick, I agree with all that. Would it be, but if it hasn't yet got the 3/4, then it's like it hasn't passed the House, and they keep, as long as the vote's still open on the floor, the members could change their votes. That was kind of the analogy I was thinking of.
Is it members changing votes, or is it multiple chambers of the legislature? So a multi-cameral legislature sort of going back and forth.
I just want to add briefly, I think Robert raises a genuinely interesting puzzle about the intersection of originalism and the Article 5 amendment process, which is specifically what happens when an amendment is pending for a very long time, right? What is the original public meaning of the 27th Amendment, which everybody seems to regard as accepted as part of the Constitution? What Madison thought it meant in the 18th century when it was proposed, what the last state legislature meant, some lowest common denominator, it's very hard to say. And I think there's an interesting question whether being an originalist commits one to something like the rule the Supreme Court got to in Dillon, which is that you need some kind of reasonable contemporaneity, because otherwise the idea, the very concept of original public meaning becomes almost impossible, right? If an amendment is pending too long and there's too much linguistic drift in that time.
So I would just say on that I think if you had a situation where you knew the House and Senate just understood a bill differently, you know, it's a prohibition on having a gun near a bank, and the House thinks that they are preventing duels by the river, and the Senate thinks that they are preventing bank robberies. You know, that would be a real problem. And you can imagine the same thing happening over time. But it strikes me, in some ways, the 27th Amendment makes me feel differently about the framers and ratifiers at Philadelphia. Because while it's true that the Constitution did not become valid until the ratifiers ratified it, the thing they were ratifying was a proposal. And maybe it's the content of the proposal and not what they thought the proposal was that matters, because they had lots of views about the proposal, but they also knew that it was a proposal that they were ratifying. And if they had just said that their thing they done proposed at Philadelphia we're ratifying, maybe that would be good enough.
I did disagree with something you said pretty strongly in your comments. And I also wanted to partly agree with Hugh on, but maybe add something to a point you were making about the validity of the 7-year rule. Your comment is that amendments, they can do anything. I'm sure there's people written on this, I just haven't read, but the word amendment is not the same thing as change. Amendment has a sense of an improvement on an existing thing. And if an amendment is not an improvement on the existing Constitution, it's more closer to a revolutionary act than a constitutional amendment. And if there is a general law of amendments, that makes Congress's statement of 7 years in the preamble has a different quality. It's maybe more valid because it's a legislative determination of an existing norm. It has to be a reasonable time. And that's already there. That's already part of the constitutional order. And I'm looking at the language of Article 5. There's ways you can make that argument from the language itself, that there has to be a contemporaneous identification of the necessity that gives rise to the power. But if that's the case, then this type of preamble is more important, not simply because it's Congress not just exercising its will, but exercising a helpful guideline to help us know that 7 years more or less makes sense in terms of keeping the preservation. And this third, a bigger point that both of you have, and this is very common in constitutional adjudication, we think of radical hypotheticals, and then ask the question, what would we do to resolve it? And especially in our time, I would say that we need to be careful about wondering whether that we is going to be there anymore. If you say we're going to rewrite the rules and you all are going to obey them, and that's what we are going to decide, that may no longer be, the institutions may not be strong enough, even if you get both houses of Congress, the Supreme Court, and majority of the state legislatures to all say huzzah in unison. That may not be enough for people to say, for the assemblage of human beings that are called Americans right now to say, okay, that's our decision.
I'm a little puzzled, or maybe I'm not that puzzled, but I just sort of disagree with your insistence late in the paper that some of the prudential considerations you point to, but of course these are not legally significant. You know, I feel like they might be, and I also feel that if they really aren't, then get them out of the paper. I sort of feel like you put them in there because maybe these considerations that you think it's really important to respect legislative intent here, or Congress's intent, or the fact that it's really important for us that we have certainty with respect to the text. That these are sort of practical considerations that you expect your readers to assent to, in a sense, and yet you say, but this is really just gilding the lily. It doesn't really matter at all. Why so sure about that? Why isn't it the case that our legal practices ground principles of prudence and practicality, pragmatism, the sorts of things you're considering, the need for contemporaneous assent, the idea of the problems that there would be for textualist interpretation if there weren't these limits, all these sorts of considerations seem really quite meaningful to me. And when you insist that, but really they don't matter at all, I want to say, maybe you protest too much. And that dovetails with Thomas's points about sociological legitimacy. I really liked his example a lot. And I really felt the pressure of that hypothetical. And I want to say, yep, in that case, the law is just as, Thomas, you're pumping our intuitions about it. And that ties into your footnote 211 on page 45, which is right in the context of this discussion. This is the West Virginia and 14th Amendment footnote, where you say, it's fortunate. It's fortunate that the answers are just as sociological legitimacy would say. What if it were otherwise? Why isn't sociological legitimacy internal to legal validity? It seems to me that our rule of recognition, flat-footedly, I would say, includes that the 14th Amendment is part of the text of the Constitution, whereas you and Will want to say our rule of recognition is our law is the original law except as lawfully changed. If we were to be uncertain about John's conclusion or Veston's and Mike Stokes' conclusion with regard to West Virginia, or maybe even thought otherwise, it seems to me that nonetheless our sociological commitments, the fact that, yep, West Virginia statutory law is still valid because West Virginia is still a state, it seems like this is really a frontal challenge to the insistence on only lawful changes count as part of our law. These are the sorts of cases where you might think actually sociological legitimacy can legally legitimate changes which were unlawful initially. So it just seems like I really love the paper, and I love all your considerations, and I'm moved by many of them, many of which I sort of shared inchoately beforehand. But I think that, to me at least, points to actually a broader understanding of the determinants of legal content than the official Sachs position acknowledges.
Yeah, thanks, Steve. This is a great paper, and I wanted to raise a methodological question about, is the 12th Amendment really that important? So the 12th Amendment was one thing that happened, and it happened a while after ratification. And there were some other things that happened you talk about, but they happened way after ratification. So I wouldn't think, for an originalist perspective, those would be useful. So, and maybe what happened with the Bill of Rights is it seems more relevant than the 12th Amendment, except that it seems a little weak. So I don't know about that. But in any event, I would think that, and here in a way I'm going to echo Larry's point, but in a sort of different way, that I would think that the opening question would be, what is the meaning of what's the original public meaning of the text? And I think that there the question is, does it prescribe a certain form for the amendment? That is, does it actually just have to say amendment, or could it be the resolution is the amendment the way you're saying it? Isn't that a question about what the meaning of proposed amendment is? And then I'd want to know what was the antecedent meaning of that? That is before the ratification. What was the practice? And I don't understand this in the way that Larry said as a. And I'm not sure if he was entirely serious, but I don't understand this as a question about the general law. I understand this as a question about what was the antecedent meaning of proposed amendments. And so it seemed to me that would be a more important originalist bit of evidence than the 12th Amendment, although I think on the 12th Amendment being a single event. But the problem, of course, is that there aren't very many events. There aren't very many post-ratification events that would be relevant to an originalist analysis. But does that mean we should put great weight on the 12th Amendment, or does that mean that, in fact, the post-ratification evidence is just not that important because we have only one substantial event? And so then just one more real quick methodological point, which is I wonder whether also there is a question about the original meaning of the ERA resolution proposal, which is, did Congress understand that entire thing to be the amendment? I mean, that you could think of that as a question of the original meaning of proposed amendments, but you could also think of it as, what did Congress mean by that when it proposed the ERA? And on that point, it seems to me that then your more recent practice with respect to the amendments becomes incredibly much more relevant, indeed much more so than the 12th Amendment. The fact that they switched from originally having it within the amendment to being in the resolution, same language, that seems very probative of what the original understanding of Congress was when they proposed it. But in either event, it seems to me to push it either much more recent or much further back, and that the 12th Amendment is actually not the centerpiece of the originalist argument.
So to take the questions in reverse order. So I absolutely agree that it matters a lot what Congress thought it was doing in the ERA. And there are some folks who argue, for the ERA's validity on the ground that they didn't really mean it. That this was more of a guideline, that it was just encouragement that it occur within 7 years, that it was a minimum of at least 7 years. There are lots of people, but I think all of the evidence from the legislative debates is exactly what one would think it is, which is that, no, they talked about this is the customary way of doing a time limit, namely putting it here, that they thought the time limit would be valid. People who didn't like the time limit complained about it because they thought it would be valid. People who thought the time limit was okay, said, don't worry, we'll ratify right away, won't be a problem, et cetera, et cetera. So I think at least as of 1972, they knew what they were doing. When we think about sort of going back, I agree that some of this is definitely post-ratification. I am comforted by the fact that starting even during the ratification debates, you see proposals for amendments, because some of the states ratify on condition, or they say, like, we want the following amendments to be considered by the first Congress, and some of them take this sort of editing form, or just sort of declaration form, rather than here is some text to tack on at the end. And then when Madison introduces his initial list of amendments, they have all kinds of different forms. And so at least there doesn't seem to be any sort of consensus against, and it seems like, some people, as I mentioned, protest against this. Some of them do it on constitutional grounds, but they're much more abstract. They're like, we're going to interfere with the beauty and purity of the instrument, and it tends to be folks who are against the amendments, and that's why other people say you're just wasting our time by protesting on these grounds. But they end up saying, fine, we'll do it at the end, because it won't matter one way or the other. And so I don't, if it had been contrary, if the evidence had pointed the other way, people were like, no, that's impossible, and that were sort of seemed to be the general tenor of things, I would worry more that by the time the 12th Amendment come around, they just forgot that rule or something like that. But I don't see that rule in at least the surface reading of proposed amendments. I don't know of any evidence, although I think it would be a defeater to my argument if there were some understanding of proposed amendments to not allow this kind of thing. And certainly early practice doesn't show such a perception. On Mitch's point, so I think this goes in general to sort of the Constitution in exile sort of debate that we have. And so I feel like there are sort of two sociological facts to worry about. There's the fact of what people think is part of the Constitution and what people think is the explanation for how that stuff is part of the Constitution. And so it matters, that the adoption of the Constitution, people just don't care that it violated the Articles, that it violated state constitutions. There's like not a problem. But they do care that it had, 9 states ratify or something like that, Article 7. And so like that, likewise, the 14th Amendment, like they do care that it was 2/3 and 3/4. And I think that that's the sociological fact that really makes the difference there. And then finally, so there are jurisdictions that differentiate between amendments and sort of complete revisions and prohibit the latter. I don't think it's easy to read that into our Constitution, in part because some of the proposals the states had might have been, wide-ranging. But I don't see an implicit limit in Article 5 if we wanted to say we're part of Canada now, that we couldn't do that via constitutional amendment.